Your Honor, the Council is appearing on behalf of the petitioner in the matter Corona Tech Solution versus the State of India. If Your Honor permits, the Council would like to narrate the statement of facts. Your Honor, in regard to this case, Corona Tech Solution is a technology giant in the world. Corona Tech Solution has expanded its business throughout the world, and Corona Tech Solution has registered is registered in the United States of America. Corona Tech Solution has developed a new technology of inscribing images, symbols, or messages on plants or any part of it, that is leaves. While expanding its business, it initiated its operations in the state of India and asked for a patent application before the Dango Patent Office. The Dango Patent Office rejected its application on the contentions that it deals with life form patenting and it is in mischief of Section 3J and it is not an inventive step. Your Honor, the state of India is signatory to the TRIPS agreement. If Your Honor permits, the Council would like to mention the issues raised. Your Honor, we have raised three main issues here. Whether the petition is maintainable and the petitioner has the locus standi to appear before this Honorable Court. The second issue which we have raised is whether life forms should be patented if technology is used to improve its existence. And the third issue which we have raised, which is the main issue here, is that Section 3J is liable to be struck down. Your Honor, if Your Honor permits, I shall proceed with my argument.
Yes, please proceed.
Much obliged, Your Honor. Your Honor, in our issue regarding maintainability and locus standi of this case, the petitioner humbly submits that Corona Tech Solution is a corporate company registered in the United States of America, which comes under the purview of artificial person. The Constitution of India has granted certain fundamental rights to persons that includes natural as well as artificial persons. Here, the petitioner has the locus to appear before this Honorable Court as there is an infringement of Article 14, that is equality before law, by the Dango Patent Office. Here, Your Honor, the Dango Patent Office is an authority under Article 12 that comes under the Article 12 under the purview of state. The denial of patent by the Dango Patent Office is a state arbitrary action. Therefore, the petitioner has the ground under Article 32 and this case is maintainable under Article 32 yet, Your Honor. In regard to this case, the action taken by the Dango Patent Office is that they have denied our patent application, which was in inscribing images, symbols, or messages on plants or any part of it, that is leaves. They rejected our application on the contentions. We are in mischief of Section 3J, which deals with life form, which is banned in the state of India, and it does not involve inventive step. Here, Your Honor, the contentions raised by the Dango Patent Office is irrational. They're trying to say just because Section 3J states that it is in mischief of Section 3J, it deals with plants, it deals with life form, you're rejecting it. They are not ready to examine our application in an appropriate way. For securing a patent, the basic criteria is novelty, inventive step, and utility. We fit into the above mentioned criteria. Here they are not examining our criteria list and they are rejecting just because we deal with life form patenting. Here, Your Honor, the petitioner submits that arbitrariness has been struck down by Article 14. Here, equality before law and equal protection of law has been infringed by the Dango Patent Office. Also, I would sum up in 2 points in regard how Article 14 has been violated. Here, Your Honor, Article 14 has been violated in 2 points. First, Dango Patent Office has acted in a discriminatory way. Second, the Dango Patent Office has rejected our application in an arbitrary way, Your Honor. The first contention of ours, how they acted discriminatorily, is that while granting patent, they are granting patents to MNCs like DuPont, Monsanto, to BT Cotton, where certain advancements have been done in regard to life form, that is plants. They are granting patents to them, whereas they are not granting patents to us. They themselves, it looks like they themselves are confused as to how to deal with life form patenting. And above all, they are taking the support of Section 3J, which itself is which itself is ambiguous and is in confusing while defining plants here, Your Honor. Also, how it acted arbitrarily. Here, Your Honor, the petitioner contends here that Section 3J confers unreasonable discretionary power in the hands of Dango Patent Office to grant or deny patent without even considering our application with the three main criteria. They have rejected our application. Here, Your Honor, Section 3J is completely ambiguous. How it is ambiguous, I'll deal it in my third issue here. The main contention is that they should have gone through the main criteria. Instead of going through that criteria, they have rejected our application, which is completely arbitrary in nature here, Your Honor. It is well known that Article 14 has empowered that no person shall be denied the right before equality. No person shall be denied the right to be heard. Here, they didn't give us the opportunity to even express what is our application, what does our application consist. Here, Your Honor, what we try to say is that in the case of Om Kumar versus Union of India, the Honorable Supreme Court has well mentioned that when an administrative action is challenged as arbitrary, it has to go through certain arbitrariness tests. The first arbitrariness test is rational and it should be reasonable. Here they are neither being rational, here neither they are being reasonable. They should consider the main criteria. They are not ready to consider. Secondly, here, Your Honor, in the case of Bachchan Singh, Justice Bhagwati has beautifully described wherever there is unreasonableness, arbitrariness, there is denial of rule of law. Therefore, the petitioner submits that the fundamental right of the petitioner, that is Article 14, has been infringed, and the petitioner has the locus to appear to this Honorable Court under Article 32. If Your Honor permits, I shall move to the second issue here, Your Honor. Your Honor, in regard to the second issue, whether life forms can be patented if technology is used to enhance its existence. Here, Your Honor, we need to understand, again, that the patent sought was in regard that inscribing images on plants or any part of it. Here we are dealing with images. There is a technical advancement being done here, Your Honor. The petitioner humbly submits that there are, as I mentioned before, I am again mentioning here, that novelty, inventive step and utility, we fit into this above criteria. Now, how we fit into this above criteria, I'll explain here, Your Honor, if Your Honor permits. Novelty. Novelty has been defined by N.R. Subbaram, Professor N.R. Subbaram, former controller of Patents, Government of India, as something that is non-obvious, not seen before. In the case of Blackie versus Latham, Justice Cotton said that for novelty, invention must include. Now we need to understand what does invention mean. For invention, we need to refer here, Your Honor. If Your Honor permits, I shall just read out section 21J, which defines invention of the Patents Act. Invention means a new product or process involving an inventive step and capable of industrial application. By reading this in simple terms, you can say we fit into the criteria of novelty. Now to understand the claim that our application does not involve inventive step. Here, Your Honor, our contention is that we need to first delve ourselves into section 2JA of invention, in regard to inventive step of the Patents Act 1970. What does the inventive step say? If Your Honor permits, I shall read it out. Inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. It seems that the Dango Patent Office did not examine our application properly. There is technical advancement as well in the form of printing, as well as there is economic significance as well. How there is economic significance? We need to refer to the fact sheet. The fact sheet clearly states there are people waiting for this product. There are youngsters who are waiting for this product. There is economic significance. Buyers are already available for this product. Buyers are already available there in the market here, Your Honor. In regard to technology, the petitioner submits that the technology term has not been defined in the Patents Act 1970, but we subscribe to the definition that any scientific advancement that leads to industrial or commercial objectives. Here, Your Honor, there is scientific advancement for a commercial objective. How can they refuse us by saying that it is not an advancement being done here? In regard to utility, there is industrial application, there is horticulture industry will be benefited by this here, Your Honor. And in regard here, Your Honor, the petitioner humbly submits that we fit into the criteria. There is technology used here. Therefore, life form should be patented when technology is used in existence to improve its existence here, Your Honor. If Your Honor permits, the Council will move to the third issue here, Your Honor. Your Honor, the Section 3J of the Patents Act is liable to be struck down as it is unconstitutional. The petitioner humbly submits that we need to again refer Section 3J of the Patents Act 1970. If Your Honor permits, I shall read it out. Plants and animals in whole or any part thereof, other than microorganisms, but including seeds, varieties and species, and essentially biological process for production or propagation of plants and animals. The petitioner humbly submits that incorporation of the words plants and animals is itself putting blanket ban on life form patenting. Here they are not defining what kind of plants or animals you try to mention. Here plants or animals, whether engineered plants or animals are to be considered, whether plants which are being modified, where certain human intervention has taken place, whether it has to be considered or not. There is ambiguity here, Your Honor, what is our contention is. And in regard to essentially biological process as well. Essentially biological process has also not been defined. Which essentially biological process this Section 3J wants to mention? Here, as according to European Patent Convention, it is well defined under Rule 23B, subclause 5, states that process for the production of plants and animals is essentially biological if it consists entirely of natural phenomena such as crossing or selection. Here, we are not dealing with biological process here, Your Honor. Our process is mere mechanical process. Where we'll print images on the product, that is plant or any part of it, that is leaf. Here, Your Honor, it is humbly submitted before this Honorable Court that I will sum up this Section 3J in 3 points. Section 3J confers unreasonable discretionary powers in the hands of Tango Patent Office. In our case, there is non-application of mind here, Your Honor. How there is non-application of mind here, Your Honor, the petitioner contends that while examining the application, they are not considering our application the 3 main criteria, as well as they are granting patents to them, to MNCs like Monsanto, DuPont and BT Cotton, and they are not granting patents to us. For your reference, Your Honor, I have the writ petition, I have the grant patent number, how they have, what Tango Patent Office has granted to Monsanto. If Your Honor permits, I shall give it for your perusal here, Your Honor.
Have you taken that ground in your petition?
Yes, Your Honor, I have taken that ground.
Where is it?
Your Honor, non-application of mind.
Example you are giving about
Monsanto here, Your Honor. We are mentioning about MNC, BT Cotton. Yes, Your Honor, we have contended that BT Cotton.
where you have your petition?
I will submit it, Your Honor. Your Honor, on page number 23, BT Cotton, in regard to Section 3J being ambiguous, it will, because of this section 3J, BT Cotton modified plants will also fall under this Section 3J here, Your Honor. Because if it's ambiguity, even BT Cotton will fall into this. Even though there is genetic process involved, they have been granted patent. Whereas our application involves mechanical process. We are not disturbing the biological process here, Your Honor. Now the petitioner, if Your Honor permits, the petitioner submits before this Honorable Court that the main crux of Section 3, inventions not patentable, is inventions should not be immoral, nor it should be harmful for the environment or society at large. Our application is neither immoral for the environment, nor it is harmful for the society at large, Your Honor. In regard to TRIPS agreement, they have taken the contention of Section 3J that it relates to Article 27(3) of TRIPS agreement. Here, Your Honor, the petitioner submits that even though if under Article 253 of the Constitution you are taking an international treaty into consideration and making a statute, but if this statute violates a fundamental law of a person, then it is to be struck down by the Supreme Court as unconstitutional. They are not ready to understand that our application is violating the basic fundamental right of the petitioner here, Your Honor. Your Honor, the petitioner humbly submits before this Honorable Court that Section 3J is ambiguous in nature. It confers unreasonable discretionary power in the hands of Tango Patent Office, and it is in derogation of Article 14. Therefore, it is liable to be struck down and quashed by this Honorable Supreme Court. If Your Honor permits, I shall proceed with my prayer.
As you have read section 3J, plants and animals in whole or any part thereof.
Yes, Your Honor.
So far as your claim is concerned, you are claiming painting on flowers and leaves.
Yes, Your
So
Honor.
your final product will be flower, printed flower or leaf.
Yes, Your Honor.
So that is prohibited.
Yes, that is what we are
As far
trying.
as your printing invention is concerned, that is not prohibited.
Yes.
When you come with a case that printing on flower or leaves,
Yes,
that
Your
is
Honor.
prohibited so far as 3J is concerned.
Yes, Your Honor.
So how you can say
That is the reason because the Dango Patent Office has rejected us because of Section 3J. It prohibits us that plants or animals is used. Here, Your Honor, what our contention is that the definition that Section 3J is itself ambiguous, is itself confusing. What type of plants or animals they want to say? They need to first define what types of plants or animals. Is genetic engineering process plant or animals will be included? Is modified plants or animals where human intervention has taken place will be included in this? And in regard to our process, we are just using the technology of printing on the organic compound. We are not disturbing its biological process. We are not doing anything in related to crossing selection here, Your Honor. We are dealing with simple aspect which will be called as advancement in technical advancement.
But that you are saying,
Yes, Your Honor.
while doing the job of printing,
Yes, Your Honor.
you will have to use the chemicals
Yes.
that will affect the biological process of the plant, flower,
Your
leaf.
Honor, our contention is that here there is no chemical involved. It is a basic. This is what the thing is.
So for printing,
Yeah.
some chemicals are required to be used.
Your Honor.
Without any chemical, printing cannot be done.
Your Honor, our contention is that the printing, this is the technical advancement in regard to printing on organic compound like flowers. This has been patented in the United States of America and various parts of the countries. This is something novel. Nobody has seen that a message coming out from the organic compound like plants. And plants, we are using it as a substance. We are not disturbing its biological process here, Your Honor. It is mere mechanical process. And when you are ready to grant patents to genetic engineering processes, what is wrong in granting patents to mechanical processes?
No, that is not described. In detail, you have not said anything in the petition. You just given the example of BT cotton. But what process they have adopted there?
Yes.
So if that is similar, then there is some substance in
Your Honor, Your Honor.
without explaining what is done in that item.
With all due respect to you, Your Honor, the petitioner submits that the reason in regard to BT cotton, it is related to biological, it is related to in regard with microorganisms where injection was done, it was enhanced here. Here, Your Honor, our contention is that we are using the plant which is available in the market, which is being sold by various people out there. We are going to use that flower which is available and imprint image on it. We are not going to harm here, Your Honor. There is no harm in our application. There is no harm in our patent application here, Your Honor. That is why the reason why we are getting confused here is that because of Section 3J. Section 3J is nowhere defining what type of plant they want to say. This is what our contention here is, Your Honor.
So please try to understand what is mentioned in 3J.
Yes.
Flowers and plants.
Plants.
And further it is mentioned that biological process.
Yes.
So the plants and flowers or
And
plants which are alive,
Yes, Your Honor.
that on that something is prohibited. It is not that, as you are saying, that some flowers are plucked from the garden and thereafter you are printing on that. That is not prohibited in 3G.
Your Honor, this is what our contention is. That if we again read Section 3J, it says plants or animals as a whole. We need to understand that this Section 3J is completely ambiguous. It is not defining, Your Honor, the scope of plants or animals needs to be specific in the Section 3J. Here the Section 3J is not being specific, whether this will be included, whether this will be excluded. Here they are just saying plants or animals. Your Honor, there has been so many interventions, so many human intervention taken place where plants have been modified. They are not considering this aspect here, Your Honor. That is why our contention is Section 3J is ambiguous in nature. It is completely ambiguous and it confers unreasonable discretionary power in the hands of Tango Patent Office, and it is in derogation of Article 14, which is the fundamental right of the petitioner. If Your Honor permits, I shall move to my prayer. Your Honor, in the light of issues raised, arguments advanced, and authorities cited, the petitioner humbly submits for this honorable court that it may hold a judge and declare that the petition be allowed. The respondent authority may kindly be directed to grant patent to the petitioner, that the section 3J of Patents Act 1970 be declared null, void, and unconstitutional, as it is arbitrary in nature, which is in derogation of Article 14, and pass any order which may deem fit to this honorable court in the interest of equity, justice, and good conscience.
Yes, sir.
Council seeks permission to address the technical So, if your lordships are members of the facts in the case, the council would like to proceed.
Yes, yes, sir.
Much better, lordship. The council and the respondents have cited 4 main arguments. First being that the writ petition is not given to the court. Second, the denial of patent does not amount to violation of Article 15 of the Constitution. Third, life forms cannot be made patentable when some technology is used to improve its existence. And in this case, the petitioner's invention does not come within the purview of invention and inventive step under the Patents Act. And the last contention being that Section 3J of the Patents Act is constitutionally valid. If your lordship want, I would like to proceed with my first argument. Much obliged. So in the first argument, the council submits that the writ petition is not legal because the responses go to the simple reason that the petitioner lacks locus standi. The locus standi in any case forms the basis for any action in a court of law which the petitioner lacks in this case. The principle of locus standi is very essential and important since it forms the legal capacity of a party to any litigation suit. And this expression is applicable to all those people who want to bring a suit for action, who want to address the court or who want to be heard in the court if they're moving under Article 32 of the Honorable Code. So, thus as a general rule, a person has locus standi in a given situation if it is possible for such a person to show that the issue is causing him harm and the matter can be undertaken by the court to redress this harm. However, in this case, the petitioners have failed to prove how they have locus standi because the council for the respondent will prove in the subsequent arguments that none of their fundamental rights are violated and hence they cannot meet to the honorable court under Article 20. In the case of R versus Paddington, Lord Denning laid down that the court would not listen to a mere busybody who is interfering in things which did not concern him, but will listen to anyone whose interests are affected by what is being done. In this case, none of their interests were affected and the denial of patent stands justified, which I will be dealing with in the second issue.
You are citing that authority?
I beg your pardon.
Very good authority.
It's of persuasive value, however the council expressed the proof.
No, you are relying therefore we are asking. We don't know anything about it. Whether you are citing that book or authority citation?
It's a case for it. No, your lordship, the council says. Please admit. Also, in the case of Power Measurement Limited versus UP Power Corporation, the court dismissed the writ petition on the grounds that none of the fundamental rights of the petitioner had been violated, and hence the petitioner lacked locus standi. So, if your lordship permits, I'd like to proceed with my second argument.
Yes.
Much obliged, your lordship. So, in the second argument, the council submits that Article 14 of the petition has not been violated in any manner and the denial of patent stands justified. In this case, the petitioners cannot claim Article 14. Every fundamental right comes with reasonable restrictions and the petitioners, being a corporation, do not have certain fundamental rights which are embodied in the Constitution of India. They claim Article 14 on the grounds that their right to carry on their creative profession has been violated, which is actually provided in Article 19(1)(g) of the Constitution. So Article 14 cannot be claimed in seclusion. The reason behind why the petitioners are claiming Article 14 needs to be seen in this case. And they are saying that the right to equality has been violated because they have not been given a right to carry on their creative profession within the student territory, which comes in Article 19(1)(g). So Article 14 in the garb of Article 19(1)(g) cannot be granted to the petitioner since Article 19(1)(g) is clearly applicable only to citizens and a corporation does not come within the purview of citizens. Moreover, in this case, when the petitioners filed a patent application, the patent officer, there was a thorough examination of the patent application, and the patent has been rejected because it falls within the mischief of Section 3J of the Patents Act. If your Lordship permits, I'd like to read out Section 3J of the Patents Act. Section 3J of the Act states that plants and animals in any whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological processes of production or propagation of plants and animals will not be considered as an invention under this Act. In this case, they came up with an invention with the help of which they could emboss and print symbols and images on parts of plants and flower leaves, which clearly violates Section 3J of the Patents Act, and they did not come within the legal framework for granting a patent to them. They've been given a fair chance to be heard. Their application has been considered. The patent has been rejected only on the grounds that it falls within the history of Section 3J. Further, it also violates Article 27 Clause 3 of the TRIPS Agreement, which India has, India has a signatory to. If your Lordship permit, I would like to read Article 27 Clause 3. It states that plants and animals other than microorganisms and essentially biological processes for the production of plants and animals other than non-biological and microbiological processes should be excluded from patentability. Thus, this also foresees the idea of patenting plants and animals as one that is not possible. Further, Your Lordship, this also falls within the mischief of Section 3B of the Patents Act. Section 3B states that where an invention, the primary or intended use or commercial exploitation of which would be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health of the environment cannot be regarded as an invention within the meaning of the Act. In this case, the invention is causing prejudice to the ecosystem and it is harming the plant life. When they are going to make the invention applicable on the plants, the value of the plant is going to diminish in its true essence. This cannot be permitted since it is a serious prejudice to the plant life and ecosystem, and further, and it has also been cited in the fact of the case that a lot of youngsters appreciated this idea and it received a lot of support from the audience. So they were using this for commercial exploitation. They are a corporation and they need motives to make profits. So they were coming up with this invention to make profits, and they wanted to patent this. They cannot be granted this patent because their motives are nullified and they're not making bona fide use of the invention. If your Lordships permit me, I would like to proceed with the
Yes.
On the third issue, the Council submits that there has been no new technology, invention, or inventive step in this case. The basic rationale of a patent system is to recognize and reward the creativity of an inventor and act as an inspiration for further invention, which contribute to the technological development of the nation. However, there has been no new novelty, inventive step in this case. Which are the basic Trinity requirements to ascertain the patentability of an invention. In order for a technology to be patentable, the new subject must involve invention over what is old. It must be of such a nature that it involves a technical advance as compared to the existing knowledge. In this case, there was no novelty or inventive steps, since such inventions have already been. People have come up with such inventions even before the petitioners, which can be seen in the case of Speaking Roses International versus the Controller General of Patents. In this case, the petitioners were granted a patent for a similar invention for providing an image on an organic product being flowers. In this case, the court also cited two other inventions. One was a patent granted to Moot for a method of etching, cutting, and altering the surface of the flower, and another patent granted to Skolky for the method of giving a message or drawing by means of applicators such as a pen, which means that there are similar inventions. There is no novelty in the idea of what the petitioners has come up with. So they cannot be granted. They've already been denied the product patent. They should also be denied the process patent because there is no novelty. There is also no inventive step. They've come up with this similar idea and are just presenting it in a different way. They're using a different method to produce this invention. Thus, there being no novelty and inventive step, which are the primary requirements, the petitioner's invention cannot be made patentable. In the case of MS Stanbic Private Limited versus MS Oswal Patent Corporation Limited, the court revoked the patent on the ground that the invention was not new and the invention did not come within the meaning of Section 3 of the Patents Act. Also, in Dhanpal State and others versus Newcomer Plastic Trades Limited, the court observed that the device developed by the plaintiffs is in fact the result of traditional knowledge and the application duplication of new products such as polymers and therefore cannot settle be an invention. If something has to come within the purview of novelty or inventive step, it should not be made known to the public in advance, and it should be a new invention which does not confer obviousness to the public. However, in this case, there was a state of prior art, and there was also obviousness to the person skilled in the art, since patents have been granted to similar inventions before, and hence the petitioners cannot seek patent for their process as well.
Given any example in your reply about the similar cases where the such permission is granted or such invention is made, but you are saying that this is not a new group.
Yes, Your Lordship, there is no novelty and inventive step is a primitive.
What is the basis for your contention that there is no novelty or this is
as the council has already submitted cases where such people have already come up with such
for
inventions.
example?
In the case of MS Stanbic, they developed a technology with the help of which they could provide an image on organic products such as flowers and leaves. Also, there are two other patents where the one patent has been granted for where you could alter the surface of a flower and with the help of a computer controlled laser energy and provide an image on it. There is another patent which has been granted. All of this has been cited in the case of Speaking Roses International versus Controller General.
But that case is not before us. You are not citing that. You are giving.
Your Lordship, the council is summoned.
Providing the image of the organic product and not for the organic product.
Yes, Your Lordship. So the council is contending that there is no novelty or inventive step, which is why they should not be granted a process patent. If Your Lordships permit, I would like to proceed with my last issue. In the last issue, the council submits that Section 3J of the Patents Act cannot be regarded as constitutionally invalid. For any law to be deemed as unconstitutional, it must violate provisions of the Part 3 of the Constitution, which has not been established in this case. A usual rational basis test is applied for determining the constitutionality of a statute, legislation, or any law. There is no explicit provision. However, the test can be applied by taking the golden triangle rule, that is Article 14, Article 19, and Article 21 into consideration. In this case, the council has already submitted to the court how Article 14 has not been violated, since it cannot be claimed in seclusion, and they are claiming it in the garb of Article 19(1)(g). Hence, if they cannot contend that the Article 14 has been violated, further, no natural justice principles have been violated because they have been given a fair chance of learning, and